Good. So it is recording. So previously we had left at section. Let me retrace. So we were to begin in section, not revivals. So we did revivals. We were to begin in on election of wills. Election here. So basically this is the Law of Succession Act analysis. This will be the last milestone. Section 24 of the Law of Succession Act talks on election, and it says that beneficiaries under testamentary gifts or dispositions shall be put to election in the circumstances and manner and to the extent provided by the third schedule. So this is a brief explanation. Kenyan succession courts have treated election as a narrow, will-specific equity doctrine that only becomes relevant where a testator purports to give away property that is not his free property. And in most succession disputes, the court instead excludes such property from the estate and leaves any ownership contest to the proper forum, often the ELC, unless the will or beneficiary facts squarely trigger a true election scenario. So the governing rules is that Section 24 of the Law of Succession Act adopts the doctrine of election for testamentary gifts and dispositions in the circumstances and manner and to the extent provided in the third schedule. The third schedule states that if a will attempts to dispose of property not the testators, but also gives a benefit to the true owner, the owner beneficiary must elect either to take under the will and allow the attempted disposition to stand, or to assert proprietary rights and then compensate out of the gift the disappointed beneficiary, capped at the value of the gift, plus rules on knowledge, implied election, disability, and no extrinsic evidence. So let us look at how various courts have interpreted the same for us to understand. Kenyan succession decisions more commonly resolve the threshold question that underpins election: is this free property of the deceased capable of passing by will at all, and will strike out or exclude non-estate property rather than run a full election compensation accounting. So property not in the deceased name or not proved to be deceased property is usually excluded from the estate. Read the decision in re-estate of Silas Kaburu, where the court held that assets not registered in the deceased name did not form part of the estate because succession deals with the deceased free property only. The confirmed grant was revoked for including such assets. Another key takeaway is where the dispute is really who owns the land, succession court declines jurisdiction and the matter will be taken to ELC route for determination of the same. And where an asset is shown to belong to someone else, this is expunged from the estate and the correct claimant must sue or act through the proper estate. Okay. Now, in practice, the courts tend to apply the doctrine in this sequence. First, they identify whether the will is purporting to dispose of property not his own. If it's simply not the deceased free property, courts commonly exclude it from the schedule of assets and may revoke or rectify grants confirmed on that basis. Second, if the will also gives the true owner a benefit or a legacy, and the will on its face shows an intention to dispose of the owner's property, then election can arise. But it must be apparent on the face of the will. If the intention can only be shown by outside material, courts will not manufacture election. And thirdly, if election is engaged, Kenyan courts will treat it as a choice with consequences consistent with the schedule. Okay. So that is it. That is applicable to a situation where somebody wants to dispose of the asset that is not a free property of the deceased person. So you have to accept the testamentary benefit where you let the attempted disposition stand, or you reject it and assert title. This is where you pay compensation out of that benefit. So this is the strict test that the court will apply in a situation where the court will give you a choice because the property that is being distributed did not form part of the free property that should be divided in this succession. Okay, so you can accept that the testamentary benefit be standing in the same. So if you have raised your hand, you can unmute and talk, because I can't see from my end. Then a continuation part, we were now to jump straight to section 26. Yes, let me confirm. Section 26 of the Law of Succession Act, that provides for provision for dependents. Provision for dependents not adequately provided for by will or on intestacy. Where a person dies after the commencement of this act, insofar as succession to his property is governed by the dispositions of this act, then on the application by or on behalf of a dependent, the court may, if it is of the opinion that the disposition of the deceased estate effected by his will or by gift in contemplation of death, or the law relating to intestacy, or the combination of the will, gift, and law, is not such as to make reasonable provision for that dependent, order that such reasonable provision as the court thinks fit shall be made for that dependent out of the deceased net estate. So Section 26 has been applied by Kenyan courts as a discretionary family provision jurisdiction. The court can override a will or intestacy only to the extent necessary to make reasonable provision for approved dependent out of the deceased net estate. It is not to rewrite the entire distribution for fairness. If you read the interpretation of Section 26 directly, it provides that on application by or for a dependent, the court may order reasonable provision out of the net estate if the will or gift in contemplation of death or intestacy or combination of both fails to make reasonable provision. So the tests that have been applied in various decisions, we can say that you must first qualify as a dependent for non-co-relatives. A maintenance immediately prior to death must be proved. Okay, if you read the case of re-estate of Helen Margaret Mary 2023, where the holding was that a nephew was not automatically a dependent, even if arguable, he had to prove maintenance immediately prior to death. Occasional help was insufficient on evidence. Another key takeaway that you must understand is that testamentary freedom exists, but it is not absolute where a dependent is left without reasonable provision. If you read the case of re-estate of Samji, deceased 2024, the court held that the court intervened where a dependence was wholly excluded and left in hardship, ordered provision 25% after weighing the estate size and the applicant's circumstances. Then the other key takeaway that you must understand is that what we mean by reasonable provision is needs-based. We look at the present and the future, not an entitlement to an equal or fair share. So if you read the case of Ulda Alo 2015, where the court held that even where dependency was accepted, the claimant had to prove needs. The court rejected an unsupported 10 million demand and instead made a calibrated lump sum provision. How do courts apply Section 26 in practice? So you have to prove the standing of this dependent. If it is a spouse or child, usually straightforward. If it is a parent or other relative, assemble proof of maintenance immediately prior to death. Then prove inadequacy and quantify reasonable provision. File a schedule of needs where you have housing, medical, school fees and upkeep, plus your income and assets. Any prior benefits from the deceased, courts will not gaze to a certain amount. Then 3, show the estate and net estate and competing claims. If administrators haven't fully disclosed assets and liabilities, court may postpone provision until proper accounts and valuation are filed. What are the situations where students will confuse when they approach this part of the Act? Students mainly get trapped up by mixing up election, pursuant to Section 24 or the third schedule, about a beneficiary choosing between a will, gift, and their own property rights, with Roman 2 reasonable provisions for dependents, pursuant to Section 26. Okay, and by treating ordinary ownership disputes as if they were succession issues. So what are the governing rules that you can take away? You can take away Section 24 on election, that the third schedule applies only where a will purports to dispose of property, not the testator's, while also giving a benefit to the true owner, forcing that owner beneficiary to choose. Okay, so provisions for dependents, on the other hand, we are extracting section 26 of the LSA. This is where this provision lets the court order reasonable provision out of the net estate on application by or for a dependent, and it is to be read together with section 29 on definition and section 28, the factors to be considered. So if you look at the various decisions, dependency is not relationship except spouses and children. Maintenance immediately prior to death must be proved if you don't fall under the angle of spouses and children. What is the ratio decidendi that was decided in Alice Atieno Ochieng versus Gregory Otieno Ogola 2012? The court found that the applicant, although a former wife of the deceased, failed to demonstrate that she was maintained or supported by the deceased after the dissolution of their marriage and before his death. Section 29 of the Law of Succession Act requires that a former spouse must show evidence of dependency at some point after divorce to qualify as a dependent. The mere fact of former marriage does not suffice. The applicant did not provide evidence of any support or maintenance from the deceased post-divorce. The court further held that claims based on contribution to property acquisition during marriage fall under the Married Women Properties Act of 1882 and must be pursued separately from succession proceedings. Consequently, the application for reasonable provision as a dependent was dismissed for lack of merits. So there are some tricky situations where a student will further confuse. Testator gave away land not in his name. This is not equivalent to automatic election. So the confusion arises where students shout election. Anytime a will mentions property not registered to the deceased is not automatic election. The correct position is to say that election only bites if A, the will disposes of property not the testators, and B, the true owner is also given a gift under the will, so they must choose. So election, you have a choice. It is that you are the true owner of the gift that falls under this will, and at the same time the will chooses to dispose of this property knowingly that this property does not form part of the deceased estate. Okay, so that's where you have the choice. So exam tip is, if the true owner gets no benefit under the will, there is typically no election. It's just an invalid attempted disposition or ownership dispute. Then key scenario number 2 is where election is not automatically courts adjusting shares for fairness. So the confusion arises where you treat election like section 26 fairness jurisdiction. The correct position is to say that election is a binary choice by the owner beneficiary, and that section 26 is a court discretion to make a reasonable provision clause. Then another situation, we have dependence under section 26 is not equivalent to say that any needy relative. So the confusion is to say that he was my brother and I'm struggling, thus you are a dependent. The correct position is to say for brothers, sisters, parents, and others, you must prove maintenance immediately prior to death, pursuant to section 29 logic, and the courts dismiss where the claimant is self-sufficient or proof is thin. Okay. Then when it comes to the former spouse angle, it also becomes challenging to the students because section 29 mentions former wife. Students assume automatic entitlement. Remember, the court have insisted that if it is a former wife, you must still prove dependency and maintenance after separation or divorce, and you must attach the evidence. And then if you look at 5 parents as dependents, and the court will split on African context evidence, students overstate that point because the confusion arises where they say parents always amount to dependents. Remember, the correct position is to say that parents must generally prove maintenance, and some decisions accept contextual inference and others demand hard proof. Okay, so a parent, in as much as it is in an African setup, they are not automatically dependents. Then another part is where we have section 26 application timing versus confirmation stage. This is where you have the procedural trap. The confusion arises where student file reasonable provision after confirmation as a normal protest. The correct position is to say that courts often treat late dependency claims as incompetent and too late. This is a procedural finality point that was seen in Alice Otieno Ochieng versus Gregory Otieno Ogola 2012. Another confusion arises where you say that I occupy the deceased land, therefore I am a dependent. Confusion arises where you say occupation or license gets argued as dependency, and the correct position is to say that court treat this as goodwill or license unless you prove maintenance or maintenance dependency situation. So mixing up section 26 dependents with creditors, the confusion arises where claimant is actually a purchaser or creditor or trust beneficiary but pleads section 26. That's not a reasonable provision. It is a debt or trust ownership claim to be proved differently, often outside succession or as a liability of the estate. Now, when it comes to also further analysis in this part, we discussed on legally adopted child versus person permanent responsibility assumption a child. So the two are different in the extent that if a person decides to formalize this legal adoption through the court process, then that child will rank pari passu with equal rights to the biological children of the deceased. But if they never went to the point of legally adopting the child, then that child will have to prove maintenance at the time of the deceased death. Okay, that is a key distinction between those confusing elements. Then we also saw when it comes to surrogacy situations that section 31 thereabouts of the Children Act 2022, it has directly prohibited contracts where you are giving away parental rights to another person. So that is to be formalized officially through the Children's Office and through the court, through a court order or other procedures that have been stipulated by the Children Act. Okay, so that the biological woman who gave birth to this surrogate child will still retain some legal rights like naming the child, etc. We also saw situations where a lady decides to okay, the deceased person died within the 9 months duration, and we call this situation posthumous child. So posthumous children are still recognized in the law of succession because it is expected that a person could have died when the lady was pregnant. So that will be brought under the succession laws, provided the test on DNA test is still maintained. Then we can say they can benefit when it comes to the estate of the deceased person. And we also read it together with the recent decision on children born out of wedlock in Islamic religion, the landmark decision by the Supreme Court case. So those were the key takeaways when it comes to section 26. Okay, so there is also another analysis on section 27 all the way to section 28 of the LSA, as giving the probate court a very wide but structured discretion, and the court may craft any form of support, but it must justify the order by weighing statutory factors, where we have section 28, needs, means, estate size, prior gifts, conduct, other beneficiaries, and the testator's reasons. So section 27 provides that you have complete discretion on form of provision, where you can grant specific shares, periodic payments, lump sum, and conditions. While on the other hand, section 28 of the Law of Succession Act provides for mandatory considerations that structure that discretion. You have to consider the estate size, the nature, dependents' income and capital needs, lifetime gifts and advancements, conduct, other dependents and beneficiaries. Let me change the brightness of my screen. To back mode bus. So moving on swiftly, we have the judicial interpretation of all courts apply section 27 to 28 of the LSA, that a dependent is not entitled to an equal or fair share. They get reasonable provision tied to proven needs and circumstances. Okay, then section 27, discretion cannot be exercised intelligently without knowing the estate. Court compelled accounts first for you to say reasonable provision. Then court ordered a monthly stipend from income of the estate. It illustrates periodic payments as a practical tool where an ongoing need exists and the estate can generate income. Then we have a conduct and the testator's reason can justify denying or limiting provision even for a child. If you read the decision of Kowalczyk versus Coley 2023, even though a biological child qualifies as a dependent, the court may decline provision where the claimant fails to disclose needs and means and where the will gives supported reasons linked to the claimant's conduct. Appellate court won't interfere unless discretion was wrongly exercised. Then what are the confusing exam traps scenarios pursuant to section 27 to 28? Completion discretion misconception. Students say that section 26 lets the judge do anything. This is wrong because section 28 is the checklist that must be addressed. Absence of evidence on needs and means commonly collapses the claim. Then dependency versus inheritance entitlement. Students argue that section 27 and 28 create a right to a share. This is wrong because it's a right to reasonable provision, not equal distribution. Then being a child helps standing, but the award depends heavily on disclosed means and needs and estate context. Failure to lay evidence leads to refusal and reduction. Then students jump to percentages before establishing net estate. Courts often order accounts and valuation first and postpone provisions. Then if the claim is really this land is mine or I bought from the deceased, that is not a section 27 and 28 dependency question. It's a property or creditor trust claim, often outside the dependency analysis. Then students think that conduct is moralizing, e.g. lifestyle. Courts treat it as legally relevant conduct in relation to the deceased estate, where they check fraud, estrangement with reasons, prior serious wrongdoing, and weigh it alongside needs, not as punishment. Okay, so the court will look at the reasons that the deceased person gave when they are disinheriting even a biological child. So section 29, who amounts to a dependent. This one I'll read verbatim because it entails a lot. So for the purposes of this part, dependence means the following. 1. The wife or wives, or former wives or wives, and the children of the deceased, whether or not maintained by the deceased immediately prior to his death. B. Such of the deceased parents, step-parents, grandparents, grandchildren, stepchildren, children whom the deceased had taken into his family as his own, brothers and sisters and half-brothers and half-sisters as were being maintained by the deceased immediately prior to his death. Okay, and C. Where the deceased was a woman, her husband, if he was being maintained by her immediately prior to the date of her death. Okay, so that was the provision that I believe was declared unconstitutional, but will confirm. So section 29 of the Law of Succession Act provides that A. Wife and wives or former wives and children are dependents whether or not maintained immediately prior to death. Section 29 provides for parents, step-parents, grandparents, grandchildren, stepchildren, or children taken in as own or siblings, including half-children, only if they were being maintained immediately prior to death. Okay. Section 29C, if deceased is a woman, her husband is a dependent only if maintained by her immediately prior to death. So what are the key judicial interpretations of this part? How have courts interpreted spouses, former spouses, and children? Maintenance proof not required, but proof matters for quantum under section 26 to 28. You read the decision of Estate of Alexander Musheni Kiago 2017. A former wife and her children qualified as dependents under section 29A, regardless of maintenance. Non-disclosure of them justified revocation of grant. Then Mary Lydia Wanjiru Mugo versus Assistant Administration General 207. The court treated multiple wives plus their children as dependents under section 29A. Distribution followed that recognition. Then extended family under section 29B. Maintenance immediately prior to death is a strict evidential threshold. You cannot navigate that. Cousins failed. No proof of maintenance immediately prior to death. And then support as an uncle or relative was not enough. Claimant failed the Section 29B maintenance threshold. Former spouse. Students often overstate automatic entitlement because the courts scrutinize dependency where the claim is framed as reasonable provision. You read the case of Alice Atieno Ochieng 2012 decision. A former wife who could not show post-divorce support failed on the facts. The court treated dependency as not established for purposes of provision. So many students will assume that Section 29A, because it has said that whether or not they were being maintained at the time of death, they will say that this is an automatic entitlement. That will be dangerous because we have been told that courts scrutinize dependency where the claim is framed as a reasonable provision. So what are the tricky situations where students mix up? They mix up dependence in Section 29 versus beneficiary on intestacy person to Part 5 of the Act. A person can be a dependent for Part 3 on relief, but still not a child or spouse beneficiary class under intestacy rules or vice versa. So don't conflict standing for Section 26 with automatic interstate shares. Then to children under Section 29A, a standing is automatic but the award is not. Students assume that being a child, they must get equal share. This is wrong because Section 29A gets you through the door. Section 26 to 28 then determine whether the will or intestacy made reasonable provision and what remedy is there to craft. Then 3. Grandchildren are not automatic dependents. They only qualify under Section 29B if they prove maintenance immediately prior to death, unless they fit taken into family as one with maintenance evidence. What about stepchildren or children taken into family as well? Must be proved factually, recognition or acceptance plus actual maintenance. Courts reject claims where paternity or acceptance is unproved or where help was occasional rather than maintenance. So former wife problems is also another tricky situation. Students miss that former wife is included in Section 29A text, but courts still expect evidence when the application is really for provision pursuant to Section 26 to 28, and the facts show separation or remarriage and independence. So the label alone doesn't win the remedy fight. So you can't approach court by saying that I'm a former wife, thus I'm entitled to inheritance. Pursuant to the reasonable provision part, the court will scrutinize. Okay, have you remarried? Those are the factors. The High Court dismissed the former wife's Section 26 dependency summons because she failed to prove she was actually dependent on the deceased after divorce or at any relevant time, and because her attempt to litigate matrimonial property or contribution issues inside her dependency application was procedurally and conceptually wrong. That is the case of Alice Otieno Ochieng versus Gregory Otieno Ogola 2012. So the material facts, so that you understand, because this is a decision that has repeated itself on various occasions as I was reading through. This was a ruling delivered on 7th June 2012 at the Milimani High Court. And the material facts are that the applicant, being Alice, married the deceased Tom in 1968, and the marriage dissolved by divorce on 6th July 1992. And the deceased died on 15th August 2007, about 15 years post the divorce. And the applicant decided to file a summons on 13th August 2009 under the LSA Section 26, seeking reasonable provision as a dependent. She alleged that 7 children with the deceased, a strained relationship with them, she had not remarried. Certain properties in the estate were acquired during marriage. She wanted specific properties and 3 to 4 million to build a house. One parcel was allegedly a gift to her from an aunt registered in the deceased name with her permission, and later tried to invoke Married Women's Properties Act that said or that talked about on contribution during marriage. What is the procedural posture? The dependency summons opposed by Administrators Council. Administrators had filed or withdrawn earlier confirmation efforts. By the time of the ruling, a confirmation application was pending and the applicant had filed an affidavit of protest against a proposed 800 Kenyan shillings allocation to her. What are the issues that arose before the court? Whether a former wife qualifies as a dependent under Section 26 and 29A in the circumstances of a long divorced spouse. And 2, whether the applicant could pursue matrimonial property and contribution claims under the Married Women's Properties Act 1882 within succession dependency proceedings. And raised in argument was the effect of Section 30 of the LSA that bar on dependency applications after confirmation of grant, though the grant had not been confirmed. Okay, so what are the rules that were applied in this decision? We saw the application of Section 26 of the LSA Act, where the court may order reasonable provision for a dependent not adequately provided for. Then we saw Section 29 of the LSA that defines dependent, including former wives or wives. Then Section 30 of the LSA, no Part 3 dependency application after confirmation of grant. That is a procedure. Then probate procedure is that protest to confirmation under Rule 46 of the Probate and Administration Rules was mentioned by the parties in court. And procedural separation, where we have matrimonial property and contribution claims, must be brought separately, and the court indicated via originating summons route, not within a Section 26 summons pathway. And the court held that dependency claim dismissed with cost to administrators, and court declined to preempt issues slated for the confirmation and protest hearing. And the ratio decidenda in this court was that the applicant did not prove dependency. There was no evidence she received supports and necessities from the deceased after divorce and before death. Although Section 29A mentions former wife, the court read it to require showing actual dependency at some point, not necessarily immediately prior to death, especially where divorce ended the spousal relationship long before death. A former wife, long divorced, is treated like a stranger unless she proves post-divorce support and dependency. A Section 26 dependency summons cannot be fused with a matrimonial property and contribution claim. The legal bases are different and the latter must be litigated separately. Article 159(2) does not excuse using the wrong procedure. What is the significance of this decision? This ruling is frequently cited for the proposition that a former spouse's inclusion in Section 29A does not automatically translate into provision. The claimant must still meet an evidential threshold showing dependency, especially post-divorce. It also draws a clean line between Part 3 dependency relief, where we have the needs and support from the net estate, and matrimonial property or contribution litigation on ownership entitlements, which should not be shoehorned into probate dependency summonses. So confusing situations where students mix up is where they treat former wife in Section 29A, therefore saying that they will automatically get a provision. That is wrong, because the court demands a proof of actual dependency post-divorce support. Then another angle is where you say that that plot was gifted to me but registered in his name. This is an ownership or trust issue, not automatically Section 26 dependency issue. I contributed to acquisition during marriage is a matrimonial property issue not determined through Section 26 summons application. Then wrong procedural vehicle, because students try to use Section 26 to get a particular parcel or percentages as if it were distribution on intestacy or a matrimonial property suit. The court rejected that blending. So Section 26 is strictly reserved for reasonable provision. Okay. Then we have the limitation of time provision. No application under this part shall be brought after a grant of representation in respect of the estate to which the application refers has been confirmed as provided by Section 71. So there is a limitation of time. So some examiners will try as much as possible to bring these limitations of time to see whether a student is keen in such situations. Then Part 4 of the Act talks about gifts in contemplation of death. And this part I'll read verbatim because it is a very tricky part. So characteristics. A gift made in contemplation of death shall be valid, notwithstanding that there has been no complete transfer of legal title if a. the person making the gift is at the time contemplating the possibility of death, whether or not expecting death as the result of a present illness or present or imminent danger, and b. a person gives movable property, which includes any debt secured upon movable or immovable property, which he could otherwise dispose of by will. And C, there is delivery to the intended beneficiary of possession or the means of possession of the property or of the document or other evidence of title thereto, and a person makes a gift in such circumstances as to show that he intended it to revert to him should he survive that illness or danger, and the person making that gift dies from any cause without having survived that illness or danger. Okay, so you underline that the person making the gift dies from any cause provided they have not survived the illness or danger, and the intended beneficiary survives the person who made the gift to him, provided that no gift made in contemplation of death shall be valid if the death is caused by suicide, or 2, the person making the gift may at any time before his death lawfully request its return. So if you have raised your hand, you can just unmute because I've heard there was an activity at the background. So this is the part where many students will be confused when it comes to the examination situation. We have seen various lecturers departing on various angles. For instance, one of the lecturers said that you can't gift a person an immovable property because Section 31 has not contemplated a situation where you can gift a movable property. But there are some decisions saying that you can gift a movable property, and we will have analysis of the same. So basically, we must exhaust all fears and rumors surrounding these provisions. Section 31, basically we refer to it as the donatio mortis causa section. It is to be construed narrowly. The claimant must strictly prove all the statutory cumulative elements, because remember we have used the word and, so it is conjunctive. Okay, contemplation of death from a present illness or imminent danger, a gift of movable property or a debt or security, delivery of possession or the means and documents of title, conditionality in that reversion if the donor survives, and donor's death without surviving the peril, and the donee surviving. Otherwise, the property remains estate property for distribution in succession. So basically, Section 31 talks about gifts in contemplation of death and validity despite incomplete legal title only if all the conditions from A to F are met, with provisos that 1. Suicide invalidates the gift, and 2. Donor may demand return before death. So all the conditions are cumulative. Failure on any limb defeats the claim. So the examiner expects a student to tick through the boxes from the factual matrix. Do you really understand the test? We will have a final review of the same after we have finished this discussion, so that we relate with what we were analyzing. In Re Estate of Late Gideon Martin Nzioka 2015, no valid gift mortis causa where contemplation of death and delivery was not proved. The court found that there was insufficient evidence to establish that the deceased made a valid gift of Syokimau farm to Joyce Matthew Nzioku, either as a gift inter vivos or a gift in contemplation of death. The requirements for a valid gift mortis causa under Section 31 of the LSA were not met, as there was no evidence of the deceased contemplating death at the time of the alleged gift, nor was there delivery of possession of title. The alleged gift inter vivos was also incomplete, as there was no written instrument or transfer, and the property remained registered in the deceased name. Furthermore, the beneficiary's mother could not gift property she did not own. In the absence of proof of a perfected gift, the court held that Syokimau farm forms part of the deceased estate and must be distributed according to the law. The court ordered that Syokimau farm and other properties be distributed equally among all beneficiaries, with those in occupation given first priority to purchase in line with Section 38 of the LSA Act and the beneficiaries' agreements. Then there was another decision in Re Estate of Musungu or Bulalo. This is a 2023 decision where the claimant failed because They never proved exclusive possession or title delivery, not a dependent or beneficiary on facts, and donatio motis causa was not established. The court found that the protester failed to prove that he was gifted any portion of the estate land by the deceased, either as a gift inter vivos, oral will, or a gift in contemplation of death. The protester admitted that he was not a dependent, never received title or exclusive possession, and there was no evidence of a valid oral will or donatio motis causa. The court held that only dependents or beneficiaries under the LSA can benefit from a gift inter vivos, and the protester did not qualify. The protester's claim of purchase or adverse possession were outside the court's jurisdiction. Consequently, the protest lacked merit and was dismissed. The application for confirmation of grant was unopposed and allowed as prayed. So delivery or means of possession is the evidential pivot. Courts reject vague assertions of "he said he gave me." Lucy Wanjiru Kamuyu versus Simon Njuguna Kamuyu 2014, where alleged gifts were not proved, absence of transfer and delivery pointed to intestate distribution. The court found that the respondent failed to prove that the deceased had made valid gifts in contemplation of death of the disputed parcels of land. The absence of transfer of the properties during the deceased's lifetime indicated that the intention was for the properties to be distributed equitably amongst all dependents. The court therefore applied Section 38 of the LSA, which mandates equal distribution of the estate among the children of the deceased in cases of intestacy. The court adopted a distribution that reflected this principle, allocating the property among the beneficiaries as equitably as possible, and rejected the respondent's proposal for a skewed distribution in his favor. Then there is another decision, Mary Grace Ayugu versus Alice Sembi 2010, where purported land transfers after death cannot be a valid motis causa, and the estate was preserved. The court found that the applicant is the lawful widow of the deceased, supported by a valid marriage certificate and the respondent's admission. The respondent's claim to be a wife is contested and not supported by credible evidence, especially given her civil marriage to another man. The purported transfer of land parcels to the respondent occurred after the deceased's death, making it impossible for the deceased to have effected the transfer or made a valid gift in contemplation of death under Section 31 of the LSA. There was no evidence that the deceased contemplated death or initiated the transfer process before his demise. The court found it necessary under Section 45 of the Act to protect the estate from further intermingling and waste, and accordingly the court allowed the prayers to nullify and cancel the land transfers. If a valid motis causa gift is proved, the asset is treated as not forming part of the deceased free property for distribution. That was in Real Estate Ngudari Bogori 2019 decision. Then, Court of Appeal upheld finding that deceased had done everything necessary to effect the gift. Caution prevented registration. Gift upheld under Section 31 reasoning on incomplete legal title. So Dhuranira versus Lauri 2023 decision, the Court of Appeal held that the deceased had in his lifetime gifted parcel number 2448 to the respondent, and the deceased had taken all necessary steps to effect the transfer, including obtaining LCB board consent, signing the transfer, and lodging the documents at the land registry. The only reason the transfer was not completed was the caution lodged by the appellant, applying Section 31 of the LSA Act and relevant case law. The court found that the gift was completely constituted and the deceased had divested himself of all legal and equitable interest in the parcel. Therefore, the parcel did not form part of the estate available for distribution. The court further found that the distribution of the remaining estate was in accordance with the law, considering both the principle of equality and actual settlement and development by the beneficiaries. So, how do you plead or prove or defeat a Section 31 claim? If acting for the alleged donee to uphold the gift, pin the peril. Do you have the medical records, diagnosis and accidents or event, evidence donor contemplated death from that present peril? Confirm it's within Section 31B. Typically involves movables, where we have cash, vehicle logbook delivered, share certificates delivered, keys, chattels, or a debt and security. Land claims are heavily scrutinized. Proof must show delivery of documents, means, and everything necessary was done. So 3, prove delivery, pursuant to Section 31C. produce the delivered item or document. Do you have the logbook or title? Do you have the share certificate, transfer forms, LCB consent, discharge documents, and witnesses to delivery? Then prove conditionality. Person to 31D. Do you have the statement on writing? Do you have witness evidence that it reverts if donor survives? Show donor did not revoke provision number 2. Prove donor died without surviving the peril and donee survived. Pursuant to 31F, E2F, where you have the death certificate and the timeline. If acting for the other beneficiaries to defeat the gift, attack contemplation of death, there was no present illness or imminent gift made long before death. Attack the delivery, there is no document to show that this gift was delivered. Attack conditionality, looks like an outright inter vivos promise or mere intention. Attack the subject matter, this is not movable or debt security or land transfer steps were not done. Procedurally raise it by protest to confirmation or by summons for revocation or for rectification, depending on the stage. So you raise it by protest to confirmation. So you do it under a protest to confirmation of grant. Okay. So what are the applications typically used in succession when Section 31 is in issue? Protest to confirmation of grant, person to Rule 40 of the Probate and Administration Rules, claiming or excluding a mortis causa gift. The title of the document is to say affidavit of protest or protest to confirmation of grant. So that is how you will approach the court when the examiner tells you to do an application to enforce a gift in contemplation of death. So the key prayers that you will use in that application is that that property be declared a valid gift in contemplation of death under Section 31 of the LSA and be excluded from the free property of the estate, that the proposed mode of distribution be varied accordingly. Then you attach your list and bundle under the supporting affidavit. Then summons for revocation or annulment of grant pursuant to Section 76 of the LSA, where a grant was obtained and distribution confirmed ignoring the gift or concealing beneficiary or assets. This is the prayer that you will seek in the summon for revocation. The grant issued on this date and confirmed in this date be revoked and annulled. The court determines whether this asset is estate property or a Section 31 gift and issues consequential orders where we have fresh administrators or redistribution. Then another procedural trap that the examiner can lay for you, summons for preservation or inhibition to stop dealings while the Section 31 question is being tried. Where there is a risk of disposal, seek inhibition or restriction orders over land or preservation orders or of other movables pending determination. This is to be filed within the succession cause. Here are trap exam fact patterns that look like a valid gift in contemplation of death or donatio mortis causa, but usually fail on one element in Section 31 of the LSA, typically contemplation of death, delivery, and means of possession or conditionality. So what are you testing in this part? Exam scenarios that confuse students with the hidden issues. So these are the facts. An 83-year-old says, I may die anytime. Take my 2 million fixed deposit. Hands over a handwritten note with account number and dies 9 months later of pneumonia after living normally. So the trap is that there is no a present illness or imminent danger at the time, pursuant to Section 31A. General fear of mortality is not equivalent to contemplation of death from a present peril. So in this situation, this gift will fail. Then 2. Hospital gift but donor recovers and later dies, pursuant to Section 31E. So facts are that donor is in ICU with severe malaria, hands donee some khakis and logbook saying, if I don't make it, the car is yours. Then later, the hospitalized man is discharged and lives another 8 months, then dies in a road traffic accident. So the trap is that the donor survived the illness and danger pursuant to Section 31E, and the gift fails even though he later died from any other cause, because this must be without having survived that illness. So if at the time he was dying in a road traffic accident, he still had a malaria, then we can say that the gift could have survived. But by the fact that he survived the illness or danger, then this gift will fail. Promise without delivery will fail, pursuant to section 31C. The fact that donor tells Anis, my shares in X Limited are yours if I die. Then there is no share certificate or CDC statement or transfer forms are being delivered. Then donor dies 2 weeks later. Trap is that no delivery of possession and means of possession and documents of title, oral declaration alone usually fails. Then there is delivery to a third party to hold for her. Is it delivery? This can be tested where the donor gives his brother the logbook and says, keep this, if I die, give the car to my girlfriend, and the brother keeps it and then the donor dies. Trap is that the students assume this is delivery. The issue is whether delivery to an agent satisfies section 31C and whether donor retained control. It can be argued either way depending on the fact. Who could recall it, who held the keys, and who had access. So when an agent is involved, this can be debatable pursuant to what you have before you. Outright inter vivos gift disguised as motis causa fails, section 31D. The donor says, this watch is yours, take it. There is no mention of if I die or return if I survive. He happens to be ill and dies days later. The trap is that this is missing conditionality and revisionary intention, pursuant to section 31D. This looks like an inter vivos gift, not donatio motis causa. An inter vivos gift is a gift that was issued during the lifetime of the deceased person. Then land gift with title deed handed over. Facts are that donor in hospital hands over the land title deed and pin certificates and says, it's yours if I die. There is no transfer or consent obtained, and then the donor dies. The trap is tested in section 31B. Is about movable property and debts secured on movable or immovable. Students wrongly assume handling a title deed automatically creates a valid motis causa gift of land. This is a classic debate point, whether it is excluded, not movable, or whether means of possession or documents of title logic can still assist. Many fact patterns are set to force that analysis. Okay, so you will argue out on what the facts provide. Then there is another situation where the donor gives an ATM card and PIN and says, withdraw everything if I die. Donee withdraws same day, donor dies later that week. Students jump to delivery is equal to done. Issues are whether this is a valid section 31 gift or an authorized withdrawal. Okay, whether there was conditionality and whether funds were still donors at death. Then we have another situation where we have donor adds nephew as joint signatory for convenience while ill. Tells him, it's yours if I die. Nephew claims the whole balance after death. Students confuse bank mandate and beneficial ownership. The issue is whether the arrangement created survivorship rights or merely access, pursuant to section 31. Still requires conditional gift delivery and there is a danger. Donee dies first. This fails. Donor hands over car keys. If I die, it's yours to his son. Son dies 2 days before donor. Donee must survive donor. Section 31(5)(f). Students forget this element. Suicide. Donor is depressed, says if anything happens and hands over valuables and later commits suicide. Proviso 1. A gift is invalid if death is caused by suicide. Revocation request before death. Donor hands over logbook. If I die, later ask for it back after recovery scare, but donor refuses. Donor dies a month later from same illness. Donor may lawfully request a return before death. Refusal undermines the gift and raises possession and ownership disputes. What is the difference between deathbed wills versus motis causa gifts? The facts are, donor says, I want you to have my livestock in front of witnesses, but there is no delivery. Students rush to treat it as section 31. Trap. This is really testing the difference between testamentary disposition will formalities and oral will requirements, and because donatio mortis causa requires delivery. Okay, so I tested on whether an immovable property is excluded from gifts interpolation of death. So as a rule, immovable property on land is excluded from gifts in contemplation of death under section 31 because the section is framed around movable property. But Kenyan courts sometimes still uphold deathbed gifts involving land where the donor had effectively delivered the means of control and title and had done everything necessary to complete the transfer. So the dispute becomes evidential and highly fact-specific. So if you read section 31b, a donatio mortis causa is liable or is limited to movable property and explicitly includes any debt secured upon movable or immovable property. The practical implication of this is that a direct gift of land is not expressly within section 31, but a debt and security, e.g. a loan or a mortgage and charge, can still qualify even if secured on land. The judicial interpretation of this part is that courts frequently reject land gift mortis causa claims where the evidence shows only intention or post-death dealings rather than proper delivery and transfer steps during life. Okay, Mary Grace Ayugu versus Alice Sembi Minayo 2010. Purported land transfers after death could not be a valid gift in contemplation of death. Lucy Wanjiru Kamuyu 2014. Alleged gifts of land not proved absence of transfer during lifetime weighed heavily. But courts have also upheld gifts relating to land where the deceased had taken all necessary steps and failure to register was due to an external impediment, often analyzed through the Section 31 lens on equality and equity. In the case of Thuranira Lauri 2023, the gift upheld where donor had executed transfer and consents and lodged documents and registration was blocked by a caution. Jackson Kanyoni 208, court accepted the gift of land where steps towards transfer were complete. Distribution followed that finding. So synthesis and how to answer: is immovable property excluded in an exam? Start with the text. Section 31 is drafted to cover movables, not land, so land is prima facie excluded. Then add the Kenyan reality. Litigants still plead gifts mortis causa over land, and courts will often reject if it's just an intention, but uphold if evidence shows the deceased delivered the means of title and control and did everything necessary to perfect the land transfer. So, key takeaways in this part: every student must understand the key takeaways provided in section 31 because they are mandatory tests. We can't answer a question on gift in contemplation of death if you have not understood the characteristics that form part of the gift. So characteristic number 1 is that at the time I'm making this gift, I'm contemplating the possibility of death and whether or not expecting death as the result of a present illness or present imminent danger. So there is contemplation of death. A person gives movable property. So this is the second threshold. This is the prima facie rule that immovable property will not form part of this part. Or there is a debt or a mortgage or a charge that is arising will form part because it is a debt secured upon immovable property. Okay. C. There is delivery to the intended beneficiary of possession or the means of possession of the property or of the documents or other evidence of title thereto. So there is delivery to the intended beneficiary. Then D. A person makes a gift in such circumstances as to show that he intended it to revert to him should he survive that illness or danger. So this is where we have the conditional rule, the reversionary interest angle. Then E, the person making that gift dies from any cause but without having survived that illness or danger. That will amount to a gift in contemplation of death. Okay, then there are the exceptions. The intended beneficiary survives the person who made the gift to him, provided no gift made in contemplation of death shall be valid if the death is caused by suicide, and the person making the gift may at any time before his death lawfully request its return. So those are the nitty-gritties that you must have at the back of your fingertips when you are answering that part. Then you have part 5 of the Act on intestacy. Section 32 provides for excluded property. The provisions of this part shall not apply to agricultural land and crops thereon, or livestock in the various districts set out hereunder. So it goes on to list various districts. Okay, Wajir, Turkana, Garissa, Marsabit, Tana River, Samburu, Lamu, Isiolo, Kajiado, Mandera, and Narok. Section 32 of the LSA carves out a narrow geographic exception. If the deceased estate includes agricultural land and crops or livestock in the listed districts, Part 5 intestacy rules, okay, person to Section 35 all the way to 40 etc. don't apply to those assets. Instead, succession is generally determined by applicable customary law, subject to the constitutional non-discriminatory rule. Because Section 32 is direct, Part 5 on intestacy does not apply to agricultural land and crops thereon or livestock in the specific districts listed. Effect in practice is that Section 33 of the LSA, customary law application to excluded property, governs what steps in customary law subject to constitutional limits. Customary law can apply in the listed districts, but it cannot be used to discriminate or e.g. exclude daughters. The ratio decidendi in Lerion, Kaole, and Tutu is that the court held that notwithstanding the provisions of Section 32 of the LSA and the application of Maasai customary law in Narok district, any customary law that exclude daughters from inheriting their father's estate is repugnant to justice and morality and inconsistent with the Constitution and Kenya's international obligations. Okay. If the land is in a district not listed, Section 32 does not bite. Intestacy is under the Act. Joseph Mwangi, 209. Nyandarua is not in the list. Customary law is excluded and distribution was made to be under the Act. The court held that Kikuyu customary law does not apply to the distribution of the deceased agricultural land in Nyandarua district, as it is not one of the districts specified in Legal Notice number 94 of 1981 under Section 32 of the LSA Act. Therefore, the distribution must be governed by the Law of Succession Act, pursuant to Section 40 of the Act. All living children of the deceased, including married daughter and the second administrator, were entitled to a share. Okay, so how do you spot the exam issue? Identify the asset. Is it agricultural land, crops, or livestock? If yes, Section 32 can apply. Okay, identify the location. Remember the question that we have in our project work. If the land is in Kajiado and the deceased man is giving away livestock that form part of Kajiado, and Kajiado is listed in amongst the district that will apply customary law, then you go to include this livestock or other assets in this land in your petition application. So the lecturer will just know that you never read part 5 of the Act. Okay, so practical steps when Section 32 is raised is that you plead and prove the nature of the land. Is it agricultural? And you check on the district and location, and then file a protest to confirmation if the proposed distribution wrongly applies Part 5 to excluded property or wrongly uses discriminatory custom. So what is the law applicable to excluded property? This is where we are saying that the law applicable to the distribution on intestacy of the categories of the properties being specified in Section 32 shall be the law or custom applicable to the deceased community or tribe, as the case may be. Then what is the meaning of intestacy? Okay, so the meaning of intestacy is that a person is deemed to die intestate in respect of all his property of which he has not made a will which is capable of taking effect. 35. Where intestate has left one surviving spouse and child or children. Subject to the provisions of Section 40, where an intestate has left one surviving spouse and a child or children, the surviving spouse shall be entitled to 1. The personal and household effects of the deceased absolutely, and B. A life interest in the whole residue of the net intestate estate, provided that if the surviving spouse is a widow, that interest shall determine upon her remarriage to any person. So this is the part that was directly declared unconstitutional, pursuant to the decision on Ripples International, because it was discriminatory, that the interest shall determine upon her remarriage to any person, but it was silent to the widower's part. So a surviving spouse shall, during the continuation of the life interest provided by subsection 1, have a power of appointment of all or any part of the capital of the net intestate estate by way of gift, taking immediate effect among the surviving child or children, but that power shall not be exercised by will, nor in such manner as to take effect at any future date. Where any child considers that the power of appointment under subsection 2 has been unreasonably exercised or withheld, he, or if a minor, his representative, may apply to the court for appointment of his share with or without variation of any appointment already made. Where an application is made under subsection 3, the court shall have power to award the applicant a share of the capital of the net intestate estate with or without variation of any appointment already made, and in determining whether an order shall be made, and if so order, shall have regard to the nature and amount of the deceased property, any past, present, and future capital, the existing and future means and needs, whether the deceased had made any advancement or other gift to the applicant during his lifetime, the conduct of the applicant in relation to the deceased and to the surviving spouse, the situation and circumstances of any other person who has any vested or contingent interest in the net intestate estate of the deceased, and the general circumstances of the case, including the surviving spouse, reasons for withholding or exercising the power in the manner in which he or she did. So basically, if you are to read the act in verbatim without applying, so one thing that you can take away is that if you are to read the act directly without having an application of the various sections, you will encounter a situation where you are reading the technical part of the act without understanding what each provision was meant to provide for. So for instance, if we break down this part, you realize that the contents that the act has decided to list is a very important context, but due to the technicality of it, you will not understand. So under section 34 the way to 35, the Law of Succession Act says that intestacy is partial if any free property is not effectively disposed of by a valid will. Where there is one surviving spouse plus children, the spouse takes household effects absolutely and a life interest in the residue, with a limited lifetime power to appoint capital to the children, and the children can move to the court if that power is abused or unreasonably withheld. So section 34 of the LSA says that a person dies intestate in respect of any free property not disposed of by a will capable of taking effect. And then we have a simplified version of section 35, 1 all the way to 5. And if we start with 1, surviving spouse gets a personal and household effects absolutely, and B, life interest in the whole residue of the net intestate estate, and widow's life interest ends on remarriage. Section 35(2), a spouse has power of appointment of capital during the life interest by inter vivos gift among children, not by will nor future dates. Then 4, a child may apply if the power is unreasonably exercised or withheld, and the court may appoint or adjust shares considering the listed factors. Then we have after death or widow's remarriage, residue devolves to the children equally, subject to section 41 to 42 and any appointments and awards. So what are the judicial interpretations? A default position on confirmation: if the beneficiaries don't agree, courts often park the whole estate in the surviving spouse subject to life interest, leaving children to await termination of life interest unless they prove unreasonable withholding and abuse. So the ratio decider in Lois Maina 2016 was that the court found that in the absence of consensus among the beneficiaries and given the clear provisions of Section 35 of the LSA, the surviving spouse, being the petitioner, is entitled to have the entire net intestate estate transferred to her subject to a life interest. The court reasoned that the petitioner retains the power of appointment to distribute the estate amongst the children during her lifetime, and any child dissatisfied with the exercise or withholding of this power may apply to the court for appointment of their share. The court rejected the protesters' argument for immediate equal distribution, holding that the statutory scheme prioritizes widows' life interest and power of appointment, and only upon her death or remarriage does the estate devolve equally among the children. The court thus ordered the transfer of all assets to the petitioner, subject to her life interest, with confirmation of the grant in those terms. If you read another decision known as Re Estate of Justice Nguyo Waititu 2019, Re Estate of Justice Nguyo Waititu, children's shares do not crystallize during the spouse life interest unless they prove unreasonable exercise or withholding under Section 35(3)-4. So the court found that in the absence of consensus among the beneficiaries regarding the distribution of the deceased estate, the law under Section 35 of the LSA must be strictly applied. This provision entitles the surviving spouse to a life interest in the entire net intestate estate, with the power to appoint all or any part of the estate among the surviving children. The court held that since the widow and children could not agree on the distribution, the estate should be transferred to the widow as sole proprietor, subject to her life interest. The children retain the right to apply for appointment of their share, as we have seen. So whenever you encounter a situation where we have been told there is a widow and the widow is fighting, okay, there is no consensus, so you invoke the ratio decidendi that was held in the case of Justice Nguyo Waititu 2019. Section 35 is to be applied strictly. So, okay, if you also read that decision, Peter Gikondo, it's also to reiterate the position. So basically there is no, all these decisions are supporting that point on the spouse taking the lead. So what do you file in practice? If acting for the surviving spouse, where we have one spouse and children, you do summons for confirmation of grant, or you propose distribution consistent with Section 35, household effects absolutely and residue to spouse subject to life interest. Then if you need to transfer or sell or regularize dealings during life interest, anchor the same on Section 35(2) on appointment, and where relevant, seek court's blessing, especially for disposition affecting children's reversionary interest. Okay. If acting for a child that is challenging the spouse's withholding or abuse power, file an application in the succession cause seeking appointment of your share under Section 35(3)-4 and or variation of any appointment already made. 2. Evidence to prepare to hit this part. You have estate inventory and valuation. Check on the spouse's income and assets. What are the children's need, prior advancements, conduct, and reasons for refusal. How will the application being brought by the child appear? In the High Court of Kenya, in the matter of the deceased, succession cause, summons or notice of motion. Under Section 35, the examiner is interested on the rule applicable, Rule 49 of the P&A rules, that the court be pleased to appoint the applicant's share out of the capital of the net intestate estate under Section 35(3)-4. The court be pleased to set aside the appointments made by the surviving spouse, that the cost be provided for. The surviving spouse has unreasonably withheld and exercised the power of appointment under Section 35(2). The applicant's needs and circumstances and the estate's nature, size justify an immediate award. Okay, you attach with a supporting affidavit. What happens where the intestate has left one surviving spouse but no child or children? Where the intestate has left one surviving spouse but no child or children, the surviving spouse shall be entitled out of the net intestate estate to the personal and household effects of the deceased absolutely, and the first 10,000 shillings out of the residue of the net intestate estate, or 20% thereof, whichever is the greater, and a life interest in the whole of the remainder, provided that if the surviving spouse is a widow, such life interest shall be determined upon her remarriage to any person. The Cabinet Secretary may, by order in the Gazette, vary the amount specified in these paragraphs. Upon the determination of a life interest created under Section 1, the property subject to that interest shall devolve in the order of priority. So basically, the interpretation of this part is that where an intestate leaves a surviving spouse but no children, the spouse takes household effects absolutely, then an upfront statutory minimum out of the residue, 10,000 or 20%, whichever is higher, and only a life interest in the balance. And that life interest ends the death or widow's remarriage. The remainder will devolve under Section 39 on kindred priority. So a breakdown of the same, we have Section 36, spouse gets personal and household effects absolutely. 36(1)(b), spouse gets first 10,000 out of the residue, or 20% of the residue, whichever is greater. Then Section 36(1)(c), spouse gets life interest in the remainder, while widow's life interest ends on remarriage. And then CS may vary the amount by Gazette notice. And 36(3), on termination of life interest, the property devolves in the priority order in Section 39. So Section 36 is routinely applied as the no children analog of Section 35. The spouse does not take the entire estate absolutely, and the spouse holds only a life interest beyond the statutory upfront share. In re estate of Joseph Oganda Oluga 2016, the court expressly restated that where a surviving spouse has no children, entitlement is household effects absolutely, first 10,000 or 20%, life interest in the remainder, and then Section 39 kicks in upon termination. The ratio decidenda was that the court held that the estate of the deceased, a polygamist who died intestate, must be distributed in accordance with Section 40 of the Law of Succession Act. This requires the estate to be divided into units corresponding to the number of children in each house plus the surviving widow, ensuring equity among all survivors. The first house, comprising of one widow and 6 children, is entitled to 7/8 of the estate, while the second house, with only the widow, is entitled to 1/8. The court rejected the applicant's proposal for equal division between houses, finding it inequitable and contrary to the statute. The court further ordered that shares, motor vehicle and pension benefits be sold and proceeds shared equally among all 8 survivors. Specific properties were allocated to the second widow to compensate for her entitlements under Section 36. The remainder of the estate is to be held by the first widow during her life interest and thereafter devolve equally to the children. Life interest is treated as statutory restriction, not optional, and remarriage must be proved if it's relied on to terminate a widow's interest. So I said that there was a decision that had an interpretation of the unconstitutionality of that part. You have to confirm and read the decision, even for purposes of orals. So students usually confuse between Section 36, where there is a spouse but no children, with Section 35, where there is a spouse and children. And Roman 2, we have Section 38 and 39, where there is no spouse. And 3, who amounts to dependence and customary law issues. The traps are about who counts as a child, life interest versus absolute ownership, and what happens on remarriage. So Section 36 of the LSA, spouse gets household effects absolutely, greater 10,000 or 20% of residue, plus life interest in remainder. Upon termination, devolves under Section 39. Widow's life interest ends on remarriage. And exam stations that confuse students, we have no children were stated, but there is a child under Section 3. The facts read that the deceased leaves a widow. Everyone says no kids. A 17-year-old shows up, and the deceased had been maintaining him and had been paying for school fees, and there is no formal adoption. Students usually jump to Section 36. Real issue is whether the minor qualifies as a child under the Act. If yes, Section 35 is the one to be followed, because Section 35 had a child and had a spouse, not Section 36. Because 36, no child, but only the spouse. Then the other fact, we have adult stepchild versus child of the deceased. A fact is where we have the widow has a 25-year-old son from a prior relationship, and the deceased never adopted him but educated him, no biological children. Confusion is where students treat him as a child and apply Section 35. Real issue is that absent adoption and recognition under the Act, he may be only a dependent claim. Separate track, so intestacy still kicks Section 36. Okay, because this is where you have to prove maintenance. Pregnancy at death, posthumous child. Widow is 6 months pregnant, deceased dies intestate, a relative say no child yet, so you apply Section 36 where you have the widow only. The real issue is that the unborn child who is later born alive is treated as a child for succession. So you move the court under Section 35, spouse and child, and not Section 36. So another confusion is where students misallocate assets. Estate, the fact says that estate is a family home, furniture, TV, fridge, plus 8 million in a bank, plus rental plots. Confusion is where students give widow everything absolutely under Section 36. The real issue is that only personal and household effects are absolute. The bank money and land in the residue is subject to the 20% or 10,000 rule or life interest of the remainder of the estate. So those are the nitty-gritties that the student ought to know how to differentiate between when it comes to succession. Another confusing element is where students mix up 20% of residue with 20% of entire estate. Net intestate estate of 5 million and household effects valued at 500,000. Confusion arises where you compute 20% on 5.5 million or include household effects. The real issue is you apply the 20% of the residue, i.e. after taking out household effects and after netting out liabilities. So it is the amount that is to remain that you will subject to the 20%. Then, if a widow remarries, does she lose everything? Widow remarries 2 years after death, estate not yet distributed, deceased left no children, parents are still alive. Students say widow gets nothing on remarriage. Real issue is that remarriage ends only the life interest in the remainder. She still keeps household effects absolutely, plus the 10,000 and 20% already vested. Then widower remarries. Student assume same rule. If the widower remarries, there is no children, deceased siblings claim his life interest ended. Confusion is where they apply the widow remarriage provision to the widower. The provision is expressly for a widow. Examiners use this test to reading accuracy and equality arguments. Then we have polygamy hidden in facts. Surviving spouse appears, but evidence shows a deceased had 2 wives under customary law. Then there was no children. Students continue with Section 36. This is a confusion. The real issue is that you must first resolve whether there is a one surviving spouse or more under polygamy, and the right provision often is Section 40, where we have polygamous setups. If there is only one surviving spouse, then you move court through Section 36. What happens if the estate includes a trust or jointly held property? There is no free property. The deceased and spouse held land as joint tenants, plus there is bank account in the deceased name. Confusion is where students distribute the joint land under Section 36. The real issue is only free property forms the intestate estate. Joint property often passes via survivorship, not intestacy, leaving only the bank money to Section 36. Excluded district mixed with Section 36 situations. Deceased was living in Kajiado. There is livestock and agricultural land and a Nairobi apartment. Lives widow but no children. Confusion is where students apply Section 36 to everything. The real issue is that Section 32 excludes Kajiado agricultural land and livestock from Part 5 of the Act. Only the Nairobi apartment and money go through Section 36. The excluded property is addressed by customary law subject to the Constitution. So Kenyan decision map cleanly onto the confusing exam scenarios, person to Section 36 versus Section 35 disputes on who counts as a child, and life interest mechanics and relatives try to bypass a surviving spouse. So we have analyzed various situations that bring out this dispute clearly. So if there is a surviving spouse and there is no children, relatives still claim. So students wrongly jump to Section 39. Where there is a surviving spouse and no children, collateral relatives, e.g. nephews, generally do not inherit. The spouse's entitlement under Section 36 will defeat them. Then, step number 2, students give the spouse the whole estate absolutely. They forget about the life interest and the statutory split that we saw. The statute gives the household effects absolutely, plus the 10,000 plus 20% of residue, plus life interest in the remainder. And the courts apply that structure, and in polygamy through Section 40, then through Section 35 all the way to 38 within houses. Then spouse plus children, but adult children argue life interest shouldn't apply. Students think adulthood cancels life interest. The holding is that life interest under Section 35 is mandatory. Children's entitlement generally crystallize on termination of life interest unless the spouse appoints capital or court will intervene. Child protester demands immediate distribution during widow's life interest. So the court will generally decline to force immediate distribution. Spouse is a life tenant with statutory protection. Courts intervene only on proof of unreasonable appointment. Okay. Student miss the power of appointment and the child's remedy. So spouse has appointment power during life interest, and aggrieved child may apply for appointment of share where power is unreasonably exercised or withheld. Okay, where there is a spouse and there are adult children, the spouse cannot sell the land, okay, without the consent of the adult children. Powers of spouse during life interest, pursuant to Section 37. A surviving spouse entitled to a life interest under the provisions of Section 35 or 36 with the consent of all court trustees and all children of full age, or with the consent of the court, may, during the period of the life interest, sell any of the property subject to that interest if it is necessary for his own maintenance, provided that in the case of immovable property, the exercise of that power shall always be subject to the consent of the court. So if it is for immovable property, the Act stresses that consent of adult children is not enough. You have to have the power that is always the subject to the consent of the court if there is a surviving spouse entitled to the provisions of Section 35 or 36. So basically Section 37 does not give a life tenant spouse a free hand. A sale during life interest must be justified as necessary for the spouse's maintenance, and for immovable property, the court's consent is always mandatory, even where adult children consent. Section 37 of the LSA Act. A surviving spouse with life interest under Section 35 or 36 may sell property subject to that interest only, with consent of all court trustees and adult children, or with court consent, and only if necessary for the spouse's own maintenance. And immovable property, court consent is always required, even if everyone consents. So court consent for immovable property is mandatory. Sale without it is illegal and it amounts to intermeddling, and the court will restrain and cancel titles. Henry Kinyua Kiuria versus Esther Wamusheke, 2013. Life interest holder could not dispose of estate land without court consent, and inhibition was even issued. Then if you read a real estate of Ngugi Mushumi Karu, 2019, sales without the mandatory consent and court approval were set aside, and purchasers treated as creditors. Consents will be granted where necessity and beneficiary protections are shown, while we have maintenance and children's welfare, plus proper accounting and clear plan for proceeds. Court allowed sale to secure alternative land, necessity or best interest were demonstrated. Consents will be refused where the application is not for the life tenant's maintenance or where accountability and consents are missing. Consent to sell declined for lack of proper compliance and accounting consents. So that is the key takeaway. How do you do a summons for court consent to sell immovable property? The client has come before you to draft this application. You approach court through summons or notice of motion. You approach court through section 37 of the LSA and rule 49 and 73 of the probate and administration rules. That this honorable court be pleased to grant consent to the applicant, the surviving spouse and life tenant to sell the immovable property, this forming part of the estate being property subject to the applicant's life interest under section 35 or 36. Where intestate has left a surviving child or children but no spouse. Where an intestate has left a surviving child or children but no spouse, the net intestate estate shall, subject to the provision of section 41 and 42, devolve upon the surviving child if there be only one, or shall be equally divided among the surviving children. If there is no surviving spouse, section 38 is the default. The net intestate estate goes to the child. If there are many, to equally amongst them, subject only to representation and advancements or support adjustments. Okay, so where an intestate leaves child or children but no spouse, the net intestate estate devolves to the child if one or equally divided. So equality is mandatory. Where intestate has left no surviving spouse or children. Where an intestate has left no surviving spouse or children, the net intestate estate shall devolve upon the kindred of the intestate in the following order of priority: father or if dead, mother or if dead, brothers and sisters, and any child or children of the deceased brothers and sisters in equal shares, or if none, half brothers and half sisters, and the relatives who are in the nearest degree of consanguinity up to and including the 6th degree. Failing survival by any of the persons mentioned in the paragraphs, the estate shall devolve upon the state and be paid into the consolidated fund. Section 39 applies only if the deceased left no surviving spouse and no children. Then inheritance follows a strict blood priority ladder. So parents have first priority over siblings where there is no spouse or child. Never forget that. Where the father ranked highest under section 39 in absence of a spouse or children, and prior grant was revoked and reissued accordingly. Full siblings and children of deceased full siblings rank ahead of half siblings. Where intestate was polygamous. Where an intestate has married more than once, under any system of law permitting polygamy, his personal and household effects and the residue of the net intestate estate shall in the first instance be divided among the houses according to the number of children in each house, but also adding any wife surviving him as an additional unit to the number of children. The distribution of the personal and household effects and the residue of the net intestate estate within each house shall then be in accordance with the rules set out in section 35 to 38. So section 40 is the starting formula for polygamous intestacy division. The net estate between houses by units. Now we have each child is equal to 1 unit, each surviving house is equal to an additional unit. Then distribute within each house under the sections. So this was tested in one of the bar examination questions, and the examiner expected to see an application of various ratios. When it comes to the division of this part, you count the total number of units per house, then you divide house number 1, it gets maybe 3 out of 10, 10 symbolizing the total number of units, and remember you have counted a child and the spouse as a unit, as 2 units separately. So there is a child 1 unit and the wife another unit. So basically whatever I'm skimming through is a direct interpretation of the arithmetics that have been applied in various situations, but they are revolving around section 40. Property devolving upon child to be held in trust, where reference is made in this act to the net intestate estate or the residue thereof devolving upon a child or children, the property comprised therein shall be held in trust in equal shares in the case of more than one child for all or any of the children of the intestate who attain the age of 18 years, or who, being female, marry under that age, and for all or any of the issue of any child of the intestate who predeceased him and who attain that age or so marry, in which case the issue shall take through degrees. So basically this will mark the end of our presentation today on section 41 of this act. Section 41 creates a continuing trust whenever intestate property devolves to a minor or to issue of a predeceased child. Administrators hold the child's share in trust until the child turns 18. Okay. Historically, a female marries under 18, and if a child of the intestate predeceased the intestate, that child's issue take their parents' share. Okay. Section 41 of the Law of Succession Act talks on net intestate estate devolving on children is held in trust for children who attain 18 and females who marry under 18. I remember that is the old law. Issue of any child who predeceased the intestate issue take through degrees. So minor shares must be held in trust until majority, and proposal to vest absolutely in adult are rejected. So when all beneficiaries are adults, section 41, trust machinery is inapplicable and the trust can be dissolved and estate vested. 1. Administrator alone may be improper where minors' interest will subsist. So the law requires at least you have two administrators when it comes to holding this land in trust. So that marks the end of our presentation today, and we will continue from section 42. We will continue from survivorship. We will continue to administration of estates. We will continue to jurisdiction of various courts, because there is a landmark decision to various interpretation of jurisdictions. We will analyze the Kadhi's court, jurisdiction of the magistrate court, appellate powers, appeals to the High Court, where you appeal to the matters of laws, to the Court of Appeal, where is the jurisdiction limited? How do you do an application for grant? Okay, forms of grant, limited grants. How do we read and interpret the probate and administration rules to make sure that the application that we will be drafting in each part is sufficient? How do you do objections to applications? Now this is where we test the applicability part in drafting documents as per the various interpretation of questions. We have resealing and resealing of foreign grants. How do you do an application to reseal a grant in Kenya? What are the powers of personal representatives? So if you look at our presentation on probate and administration paper of 2015 paper was very difficult, because the examiner at that time decided that, okay, these students have mastered all other parts that predeceased all other parts of this act, but they have never mastered the last parts of this act. And the question heavily tested 80% on trust. Okay, so the examiner decided, okay, let us see to what extent do you know about trust. So ilikuwa inauliza about questions that required section 80, 85, nini applications. Duties of a personal representative, accounting part, do you know how to draft a memorandum of a schedule of assets? Okay, so ilikuwa very technical, and I challenge you to also have a look at it. It was a very technical paper, majorly focused on trust. On hapo kwa watoto where two are the required, wameshikilia in two, so those are the things. So we won't ignore pia the last parts of this act. We'll go through it. Tutapitia probate and administration rules. We'll look at various forms of grants. Okay, generally for oral purposes, because pia tutaangalia the various types of grants as per where the lecturer alifunza, then everything will be good. So currently, so unaona, investment of funds to provide for legacies and interest on legacies. Investment issues pia zilikuwa zina arise when it comes to the trust angles of 2015 paper. So that is it. So we have covered the Law of Succession Act. At least now to move forward. Now tunaingia kwa drafting part of the Law of Succession Act, of which sasa ita beg a question that we have to analyze the probate and administration rule by rule. We see this is the applicable application. This is why we are drafting this application. These are the prayers to seek. So to avoid ile confusion where a person anataka school fees, mwingine anataka preservation, mwingine anataka for purposes of suing only. How can we have those applications at the back of our fingertips without cramming? And that is the essence. So that once tumemaliza Law of Succession Act and probate and administration rules, we are assured of a pass in Law of Succession Act, because the project work now sasa tutaweka uzito na orals. Unaona, uzito kwa project work, then tutasafisha mkono because there is no issues when it comes to the Law of Succession Act. Probate and administration rules sijasikia ikiwa ngumu over the years. So hiyo energy tunairusha wapi? Remember professional ethics, tumecover Advocates Act, SOPEC rules ndio nimemaliza kuanalyze. I've said that we will have a session on SOPEC rules. We go rule by rule, we look at the decisions zenye nimeattach pale just in a similar way. Okay, juu SOPEC pia iko na interpretation nyingine iko very strong, na you can enter into the professional ethics question room, examination room ukidhani umeiva ethics lakini upate uko zero. So that is one unit that can give us nightmares in Kenya School of Law. So hiyo uzito lazima tumalize SOPEC, lazima tuguze LLP Act. Remember kuna some acts in commercial transaction hatujaguza bado, and it is dangerous if we are to approach exam kama tujaguza some acts. Companies Act, various modes of requesting for a meeting, hizo vitu, how do you open a foreign company, nini, we must do that. LLP Act versus general partnership, very common questions kwa commercial transaction papers. Then tuingilie hii inaitwaje, kuna another substantive, criminal litigation. I told you criminal litigation sahi ukiangalia the trend ya April 2026 pia kuna a certain trend that if a unit imeanguka pia inaweza anguka mara ya pili. Kama professional ethics imekuwa ikianguka for 5 consecutive trends, what if sasa pia wameanza kuguza criminal litigation? I told you that criminal litigation is ready, and this requires a step by step analysis. Label kama Criminal Procedure Code Section 1. And criminal litigation pia iko na very many applications inside. So pia ni one area yenye hatufai kuingia orals kama hatujamaliza this act. Do you know how a plea is taken? That procedure, pole tu. Amesema guilty nini, amesema hivi, what do you record nini, iko na practical elements. In fact, when it comes to priority, I will give criminal litigation more priority as compared to professional ethics. Once you have understood the Advocates Act, at least you have a rumor. Jujaguza SOPEC, you have a rumor. As compared to criminal litigation, you have not read the Criminal Procedure Code. You don't know the various applications applicable. Na wewe ni DPP, wewe ni the the advocate of a minor. Do you know how joint of counsel? Basically, next week, priority criminal litigation and commercial transaction on LLPs, companies and general partnership. SOPEC kwanza itachill kwanza to address the urgency on criminal litigation and commercial transaction, then we will resume. Hizo zingine ni gani? Itakuwa imebaki extensive, itakuwa imebaki gani? Civil tulianza analysis of the civil procedure rules, tuko huko order 10. Okay, hiyo ina shida juu tumeenda polepole hiyo, and it's one uzuri, that is one ukipita civil procedure code vizuri and all the annexures zenye ziko hapo, that is a guaranteed A. Ukiingia which other unit, trial advocacy, LPM nimewapanga. I have analyzed the full cause outline, and with the cause outline iko na zile nitty-gritties that you are expected to master in that unit. So trial advocacy tulisema pia kuna mahali orals wanaweza kushika vizuri. On cross examination lazima evidence act tuchambue. On cross examination, re-examination, examination in chief. Okay, so those are the nitty-gritties zenye ziko na technicalities in trial advocacy. How do you make a closing and opening statements? So those are the heavy duty areas to master. Hizo mbili so far, hizo tuko sawa. Trial, LPM, nini ingine, commercial transaction nimetaja, criminal nimetaja, civil nimetaja, professional ethics nimetaja, conveyancing ni very procedural. Tumefanya session on its own, iko 3 hours. Majority of the applications or procedures ziko pale, unaona, so that is extensive. Conveyancing pia, the trick is to analyze the cause outline, because by the fact that procedures ni mingi, unaweza soma pia vitu ziko kwa cause outline rahisi. So once tume analyze the cause outline before orals, tulisema the mode of analyzing the cause outlines in preparation of orals is we are doing what the school expected of us on our feet. Tukisema ni sell by auction, naingia pale Google, naangalia, nasoma these are the steps, then we go to the next, venye tu tulifanya na civil procedure nini cause outline. So up to that point, that marks the end of this recording, and I'm uploading the same in YouTube. So all this time sikuwa nime project Law of Succession Act. Amko mnaongea wala, I thought nilikuwa na share screen. Kama mtazipata kwa recording, I thought nilikuwa na share screen. Allah. So Albert Ringera, any closing statements? I think I've finished.